All right, let's start this up. Good day to every one of you. I can see that a few of you are on Facebook and the rest of you are on Zoom here in my right screen. It's great to have you. Special welcome to everybody who's listening, international students or people outside of the Netherlands, but also, of course, our Dutch listeners and viewers. Van harte welkom. My name is Jos Hummelen from both CIDI and NGIZ, NGIZ. Dat is Nederlands Genootschap voor Internationale Zaken oftewel Dutch Society for International Affairs. We cooperate in this webinar. Special welcome to our guest of today, our expert, Matthijs de Blois, who I will be introducing shortly. But first, this webinar will be about Israel and international law. It will be available on demand on YouTube. We have our own channel. It's called CIDI TV. Make sure you look us up. If you have questions, and you're very welcome to ask questions, critical questions, open questions, not statements, questions. You can put them in Zoom. If you're following via Zoom, there's a button Q&A below. And if you're watching via Facebook, you can leave your questions in a comment section. Like I said before, Matthijs de Blois is our expert of today. He's a senior fellow at the Hague Initiative for International Cooperation. It's called thinc, so think with a C. Look it up. It's www.thinc.info. He discusses the history of Israel and the right of self-determination of the Jewish people. He also wrote a couple of books. I want to mention two. One of them is with Andrew Tucker, also of thinc. The book is called Israel on Trial. The other one I want to mention is a Dutch book. It's called Israel, een staat ter discussie. I think the letter is available via bol.com. We will talk about international law in general, but we will talk later about territory and borders, human rights, and law of war. So if you have questions, feel free to ask them. The floor is yours, Mr. de Blois.
Thank you very much. Good morning to everybody. And indeed, our topic is international Israel and international law. And that is, I think, an important topic. Israel, the state of Israel, faces many challenges in the field of international law. We only have to think about its the ongoing and long-lasting conflict with the Palestinian Arabs about territory, borders, settlements, the position of Jerusalem, and so forth. We can think of the nuclear threat coming from Iran, a state blatantly anti-Semitic with the purpose to erase Israel from the face of the earth, and which is developing nuclear power. We can think of a procedure now pending before the International Criminal Court in The Hague, where the so-called situation in Palestine has been submitted before the court by the prosecutor. And it is about what happens in the what in the newspaper is called the occupied territories, the disputed territories, Judea, Samaria, Gaza. And well, we will have to see what will come from this procedure, but it is an international issue. We can think also of what's happening within the United Nations. Very recently, a new committee was established, a commission of inquiry to investigate also the situation in the OPT, the occupied Palestinian territories, including East Jerusalem, and with a very broad mandate. And that is maybe an example of the position in general within the UN vis-a-vis the state of Israel. We can think of international law issues when it comes to the labeling of products coming from the disputed territories, from the settlements. In the Netherlands, that is now an issue, but also in the EU, according to EU law, there are problems. And we can think also recently of the accusation made by Amnesty International that Israel is an apartheid state, also referring to the international law. So there are many challenges in the field of international law. I'm not sure whether many of you are law students or lawyers. I guess many of you are not. So we first will say a few words about what is international law in general. And then we move on to the existence, the position of the state of Israel in the light of international law. After that, we will dwell on the issue of territories and the territorial questions, and then move on to the human rights issues, and finally discuss the laws of war that are relevant for the position of the state of Israel. But first of all, a few words about international law in general. Many of us are accustomed to national law. We are all, I guess, citizens subject to international law. We have to the legislature making laws, to the judiciary making binding judicial decisions, to the executive also making binding decisions on our lives. We are accustomed to that. We may have some influence when there are elections, as today in the Netherlands, but in general, we are subject to international law, whether we like it or not. We cannot say we do not like this court, so we will not follow its ruling, or we cannot say we do not like this law because it is against our convictions, but we are bound by it, and that is inevitable. So that is the situation in a national state, a kind of vertical structure where we have the government and below the state, and then we are citizens, we are bound by it. It is kind of vertical structure. In the international world, it is different. In international law has a kind of horizontal structure. The international community is composed of about 195 independent sovereign states. In principle, they decide whether or not they will be bound by law, whether they will follow up decisions made by international courts. Law is made by states. They conclude treaties, that is kind of agreements with other states, sometimes with international organizations. They decide also on the enforcement of international law in principle, and they are not bound by international courts unless they have said that they will be bound. They have accepted the jurisdiction and of this court. So it is a horizontal structure. Of course, that is not the complete picture. We have international organizations, sometimes with mechanisms and institutions to enforce the international law, like the Security Council of the United Nations, or in the European Union. Of course, there are many there are bodies like the Commission that can enforce the law, and also there are international courts, the International Court of Justice in The Hague, and the Court of Justice of the European Union in Luxembourg, or the European Court of Human Rights in Strasbourg. But in principle, states are only bound by these courts when they have accepted their jurisdiction. So that is different as compared to the national state. Then, who are the subjects of international law? What are the entities that have rights and duties under international law? Well, first and for all, the states. States are subject of international law. And what is a state? Well, in international law, there's a very clear definition. It is an entity that has a territory with a population and an effective government that has the power on that territory. The size is not important. Russia, the Russian Federation is a state, but also San Marino or Monaco in France, in the south of France. So that are states. And next to that, we have as subjects of international law, international organizations like the United Nations, like the European Union and many others, NATO. The United Nations is important also for the discussion on Israel. We have in the United Nations, the main body is the General Assembly, composed of representatives of all member states. We have the Security Council, composed of 15 member states, including the 5 permanent members. We have the Secretary General, and also the International Court of Justice is an institution of the United Nations. And some other bodies also, like the United Nations Human Rights Council, for example, that is a subsidiary body of the General Assembly. Also, these are the international organizations. Next to that, we have individuals as subject of international law. Indeed, in international law, there are some duties that binds us as individuals in the field of, for example, humanitarian law, the laws of war. War crimes can be prosecuted for international tribunals. In the past, already in Nuremberg, and now these days in the International Criminal Court in The Hague, where individuals can be prosecuted because of genocide, crimes against humanity, war crimes, and crimes of aggression. But individuals do also have rights under international law. Think of the whole body of international human rights law. Many treaties about human rights within the framework of the United Nations, or sometimes within other frameworks like the Council of Europe. So that about individuals as subject of international law, and also peoples are subject of international law. Peoples have a right to self-determination under international law. And as such, they are a subject of it, to be distinguished from states. And peoples are not automatically becoming or creating a state. So that about the subjects. And then the next question is, where do we find international law? What are the sources of international law? So the first source is the treaties, or sometimes called conventions. In principle, that are international agreements, like contracts we make as citizens among each other. States can conclude treaties with each other. Many, many thousands of treaties have been concluded. Sometimes think of the Charter of the United Nations, which is a worldwide treaty, but we also can have treaties with our neighboring countries about the borders, like between the Netherlands and Belgium, about the border in the river, the Scheldt River, and so on. Next to that, we have, next to treaty law, we have customary law. Customs, practices by states can become law if they are accepted as such, if there is an opinion that we are bound by it. In international law, customary law is important. Then we have next to that general principles of law, principles that are sometimes also relevant for national legal systems, like the principle of good faith, or the principle that you have of restitution in case of unjust enrichment, and some other principles are important in international law. And next to that, we have sometimes binding decisions of international organizations. In certain situations, for example, the Security Council of the UN can make binding decisions in exceptional situations. Mind you, not all resolutions made by the Security Council are binding, not at all. And the General Assembly also adopts many resolutions. They are not binding law. They're just expressions of an opinion. Next to that, we have subsidiary sources of international law, like judicial decisions. So the case law of the International Court of Justice, for example, and also in international law, the doctrine of very famous writers like Hugo Grotius or Pufendorf may play a role as a source of law.
May I ask a question in the
Mhm.
meantime, while you're having
Yes.
your water?
Yes.
Are there colleagues of yours, Mr. de Blois, who disagree with you and say the UN resolutions of the Security Council or the General Assembly are in fact international law?
Well, there is a debate going on that, but I think according to the Charter, in my view, it is rather clear that only resolutions adopted under, and it sounds a bit technical, the Chapter 7 of the United Nations Charter are binding. That is resolutions in case of a threat of war, and they are binding, but it is very clear from the Charter, in my view, that General Assembly resolutions and other Security Council resolutions are not binding, but they can contribute sometimes to the development of international customary law. That's another thing. But as such, they are not binding. And you come across many writings, of course, also in newspapers, etc., that assume that they are binding. And there is some debate. Some people say it is soft law, so it is a kind of law. But I think if we look at the Charter, and I think that is the most important thing in this respect, the states have accepted powers of the Security Council and the General Assembly when they adopted the United Nations Charter, and it was very explicit that General Assembly resolutions, for example, would not be binding.
Maybe I got a
Yes.
good example. I think maybe you can elaborate on it later. But one of our students already made up his mind, and
Yes.
he's saying Israel is an apartheid state. What is your
Yes.
answer to that?
Well, we come to that. I can postpone it. I can answer it here, try to answer it here, but I think it's better to discuss that in the framework of our human rights discussion. I think I have it on my paper, so I will come back to that because it is a very topical issue, of course.
Great.
Okay. The final remark about international law in general is that it is closely related to politics and intertwined with politics. And an example is, in my view, what happened in 2004. The International Court of Justice adopted an advisory opinion on the security barrier in Israel or in the disputed territories. That was an advisory opinion. The International Court of Justice has two powers. They may decide in conflicts, and they can then give a binding judgment, but they also can give advisory opinions at the request of United Nations, organs of the United Nations. And these advisory opinions are, as the word says, advisory, they're not binding. But what happened in 2003, the General Assembly of the United Nations adopted a resolution to ask the International Court of Justice about the security barrier created by Israel after the Second Intifada in 2000 and further, to protect its citizens against the suicide attacks. A very effective means to do so. But this security barrier was built partly on the eastern side of the so-called Green Line. That is the armistice line, in fact, of 1949, or sometimes called in the papers the borders of 1967, after the Six-Day War. They are just armistice lines, but nevertheless, they are sometimes seen as international borders, which they are not, I have to say. But, well, the security barrier was built partly east of that line, and it was held by the majority of the General Assembly that was against international law, and they asked for an opinion of the International Court of Justice. The Court of Justice then decided to accept this request. They are not bound to do that, but they decided to accept it, and they gave a ruling on that, which said indeed the security border is against international law. They, in passing, they also remarked that the settlements, Jewish settlements, are illegal, which was not, strictly speaking, part of the request, but nevertheless they said so. And why do I mention this? This advisory opinion played an enormous role in, still plays an enormous role in the debate on Israel and international law. It is, in my view, it can be criticized for many, many reasons. And but also the court could have refused the request. Maybe that was much better, because the whole issue was part of the negotiations between Israel and the Palestinians. It was a highly sensitive matter, and then to impose a judicial view on that sensitive political matter is not very advisable for coming to a solution. So the court made a decision, and it was so, but the initiative for that was purely political. It was the request by the majority of states in the General Assembly that asked for this opinion. So that illustrates the intertwinement between international law and politics, in my view. Okay, this so far so good about international law in general. Now we come to the State of Israel in the light of international law and how it was created. Well, my starting point is 1897. 1897, I guess in this series you have already heard about Zionism and its history. 1897, the first first Zionist Congress in Basel, in Switzerland, and there they adopted the so-called Basel program, and they formulated there as the aim of Zionism is to create for the Jewish people a home in Palestine secured by public law. These are the words. So a home for the Jewish people in Palestine secured by public law. And that was the aspiration of the World Zionist Organization. And they were looking for support among the great powers of those days, like Russia, like Italy, like the Pope, France, but also the British government. And there they were, in a sense, successful, because the British government expressed its opinion in the Balfour Declaration, and maybe you have heard of it, the Balfour Declaration, where it was said that His Majesty's government views with favor the establishment in Palestine of a national home for the Jewish people, and understood that nothing will be done which will prejudice the civil and religious rights of existing non-Jewish communities in Palestine, or the rights and political status enjoyed by Jews in any other country. So that was the Balfour Declaration, adopted in the midst of the First World War. At the same time, British troops were fighting against the Ottoman Empire, part of the Central Powers like Germany, Austria, and Hungary, and also the Ottoman Empire. And it was adopted the 2nd of November 1917, and a few weeks later, the British troops entered Jerusalem. And this principle, it was an expression, a unilateral expression by the British government. It was accepted by other countries like France, but it also played a role later on in the peace negotiations after the First World War. They started in Versailles, near Paris, but when it came to the issue of and within the peace treaty of Versailles included the institution or the creation of the League of Nations, kind of predecessor of the United Nations of our days. And within this League of Nations, they created a structure to deal with the former colonies of the powers that lost the war, like Germany, but also about the Ottoman Empire, which was already in decay and which also stood on the wrong side of the war, so to say. We lost the war. And they created for these colonies and parts of the Ottoman Empire a mandate system. That was quite a new idea, inspired by the American President Woodrow Wilson, to deal with colonies. Not the old-fashioned idea was to create, to take the colonies. The victors would take the colonies of the parties that lost the war. But no, they created a system to lead peoples and territories to independence under the guidance of one of the powers, another state. And that was the mandate system. And also for the Ottoman Empire, parts of it. And in San Remo in 1920, the Supreme Allied powers of those days, like France, Britain, Japan, Italy, and also the US, discussed what had to be done with the parts of the Ottoman Empire, like Palestine, like a geographical indication, like Syria, Lebanon, Mesopotamia, etc. And they decided to create mandates for these parts of the world. And they decided also to create a mandate for Palestine with the British government as the mandatory. And that resulted in the adoption of the mandate for Palestine on the 24th of July, 1922. And that is a very important document for the creation of the state of Israel, in my view. And what about this mandate?
Just a quick question about
Yes.
that, because I'm guessing everybody here knows about for example, the Balfour Declaration, the
Yes.
partition plan. But is it justifiable that San Remo is less well known in your view?
Well, I'm not sure whether in San Remo, I think the main decisions were made for which led to the creation of the mandate for Palestine. Already the mandate system was known, the Treaty of Versailles was adopted, but then they had to elaborate on that and decide on what had to be done with the parts of the Ottoman Empire, like Palestine, like Syria, Lebanon, etc., etc. And then they adopted a binding resolution, indeed, the great powers of those days, and they decided, but that had to be implemented within the League of Nations. So formally speaking, the mandate for Palestine was adopted by the Council of the League of Nations. Not only these four powers as the four the victors of the First World War. So it was a wider support of within the League of Nations, and they adopted on the basis of Article 22 of the Covenant of the League of Nations the mandate for Palestine. And the mandate, I think we have to say some words about that, because I think that is important. The mandate for Palestine was there and quoted the same words as the Balfour Declaration. The main obligation is to be found in Article 2 of the mandate, which says the mandatory shall be responsible, mandatory, that's the British government, shall be responsible for placing the country under such political, administrative, and economic conditions as will secure the establishment of the Jewish national home as laid down in the preamble, and the development of self-governing institutions, and also for safeguarding civil and religious rights of all the inhabitants of Palestine, irrespective of race and religion. That is, in a nutshell, what is the mandate is about, and that is well, similar and the same, in fact, as the Balfour Declaration, but that was then accepted by the international community of those days. And this mandate has a unique character. First, looking at the beneficiaries. The beneficiaries of the mandate are the Jewish people as such, not only the Jews living in those days in Palestine, that was a minority living there, but it was the beneficiaries were the Jewish people as such all over the world, so to say. And that makes this mandate unique, because the other mandates were related to and benefited the population living in a specific territory, like in Lebanon, Syria, Mesopotamia, etc. But this has a and that is clear from the mandate, because it provides, for example, in Article 6, for the right to immigrate to the land, to settle there, close settlement by Jews on the land, Article 6. It provided for a appropriate Jewish agency to serve as a public body for the purpose of advising and cooperating with the administration. It creates the possibility for a nationality law that to facilitate the acquisition of Palestinian citizenship, as it was called then, by Jews to take up their permanent residence in Palestine. So it was clear from the whole text that this was about the Jewish people as such, that had a right to immigrate to the land of their forefathers in the geographical area of Palestine. And it is also unique in another respect when it comes to the powers of the mandatory. Article 1 of the mandates says that the mandatory has full powers of legislation and administration under the mandate. And that was also different from other mandates. And it was necessary to make it possible for the Jewish people to immigrate and to settle, because there was already also in these days a lot of opposition against it. The mandate talks about the Jewish national home. It does not mention Jewish state. And that is, it used the formula already taken by Herzl in 1897, a home for the Jewish people, Jewish national home. And that was also in the Balfour Declaration and San Remo, and also in the mandate, that it was clear, if you look at the history, that the intention was that it would eventually emerge into a Jewish state. And that was also the whole idea of the mandate system, that was about leading peoples and territories to independence. But what was the justification of this special character, special nature of this mandate? Well, they are given in the preamble of the mandate. It refers to two things. First, the historical connection of the Jewish people with Palestine. There has been always a connection from biblical times until then, until now, with the territory. That was the first thing. And the second was the grounds for reconstituting their national home in that country. And that refers to the suffering of the Jewish people within the Western world throughout about 2,000 years of persecution, of threats of annihilation, of, in the 19th century, the pogroms in Russia, in Romania, etc., etc. And that is one of the reasons to create a safe haven, a place for a Jewish national home in the land of Palestine. It has been defended by Balfour, but I think that takes too long to elaborate on that. But that was these are the reasons given in the mandate. It refers to a Jewish national home in Palestine. That presupposes that there are also other people living in Palestine. And that was clear right from the beginning. Initially, the territory of the mandate extended from the border of the Mediterranean to the eastern border of present-day Jordan. So also on the eastern side of the Jordan River. And the mandate included a provision that made it possible for the mandatory to postpone or withhold the application of provisions of the mandate east of the Jordan. And the British government applied this provision with the approval of the Council of the League of Nations. And that because they had in mind to create there, on the eastern side, an Arab emirate, which eventually became the Kingdom of first Transjordan, now the Kingdom of Jordan. So that was provided for. So more than half of the original mandate territory was no longer available for the creation of the Jewish national home, only the part west of the Jordan River. So in the broader area of Palestine, indeed, it was a Jewish national home in Palestine, rather than the whole of Palestine as a Jewish national home. Well, the history of the mandate is not so very impressive. We see in history a retreat by the British from their obligations under the mandate, leading up to the White Paper of 1939, which in fact made it impossible for the creation of eventually a Jewish state, and restricted the immigration to a great extent in the days that it would be so very important to have a safe haven for the Jews, which were subject to persecution in the German Third Reich, as we all know. But then the Second World War, and we know everything what happened then, the Shoah, and we will see what happened after that. But first, I will make a remark on the legal relevance of the mandate before we leave this issue. The mandate is still relevant in legal terms, and therefore we have to look at Article 80 of the UN Charter. Article 80 of the UN Charter is a transitional provision from the mandate system under the League of Nations to the trusteeship system under the United Nations Charter. And it provides that in Article 80 that until trusteeships agreements were created in respect of former mandate territories, like Palestine, the rights of the states and peoples, I underline, under the mandate system should be respected. That means that the rights of the Jewish people under the mandate should be respected, also under the new UN regime. There has never been created a trusteeship in respect of Palestine. So still the rights under the mandate are relevant, and they're especially relevant, of course, when it comes to controversial issues like the settlement of Jews in the what they now call the West Bank, Gaza, etc. And that is an important provision. It is sometimes called the Palestine Clause because it was created mainly because of the rights under the Palestine mandate, the rights of the Jewish people. Okay, then we move on to the territorial issues. What was the territory of the mandate? I said already, initially from the Mediterranean to the eastern border of Jordan. Later on, the part for the Jewish national home was restricted to the part west of the Jordan River. And well, after the Second World War, the British want to get rid of the mandate. They wanted to leave, and they asked the United Nations to give them an advice on what to do after that. That resulted in the partition plan. You are familiar with that, I understood. That was adopted by the General Assembly in 1947. Partition plan meaning that the part of the mandate territory would be subdivided in a Jewish state and an Arab state. A very small part of the original mandate territory for the Jewish state and another part for the Arab state. That was adopted reluctantly, but nevertheless by the representatives of the Jewish community. They were facing enormous problems, survivors coming from the camps and had nowhere to go. So they should have a safe haven. So they accepted the partition plan, but the Arabs, both in the territory of Palestine and the Arab states surrounding them, rejected it forthwith. So the partition plan came to nothing. Then we have the War of Independence, Israeli War of Independence, 1948, 1949, because Israel, it was declared its independence on the 14th of May, 1948, and immediately 5 Arab states started a war against Israel with the purpose to bring a Jewish state there to an end, to erase it from the map. That was not, thank God, not successful, but that resulted in a situation in 1949 when Israel concluded armistice treaties with Lebanon, with Jordan, with Egypt, with Syria, leading to borders or no armistice lines, and which resulted in a part controlled by Israel, which was a bit larger than the partition plan, but smaller than the original mandate territory, and a situation which lasted until 1967. Then we had a 6-day war when Israel brought under its control what was called the West Bank, because the West Bank was occupied by Jordan in 1948, and it was annexed by Jordan in 1950, and but it came under Israeli control. The biblical names are Judea, Samaria, in 1967, and also they succeeded in unifying the city of Jerusalem in 1967, because Jerusalem had been divided as from 1948 by the Jordanians, the eastern part controlled by the Jordanians. They demolished the synagogues and they expelled all the Jews, and Israel controlling the west part of Jerusalem. But it was united in 1967, and it was, as from that moment, also seen as part of the state of Israel. Israel, yes, it was, the word of annexation was not used. Some people say, well, you do not have to annex what is already yours, but they extended the application of Israeli law through the whole of Jerusalem in 1967, and they adopted in 1980 the basic law on Israel as the capital of Israel.
May I ask
Jerusalem
about
as the
the
capital of
Golan
Israel.
Heights?
Yes, the Golan Heights, that is another issue that was also controlled, brought under Israeli control in 1967, and it was a special case because it was not part of the original mandate territory. It has been the intention to bring it under the Palestine mandate, but eventually it became part of the Syrian mandate controlled by the French. And after that, Syria became an independent state, and they used the Golan Heights, then belonging to Syria, as a launching to launch rockets into the Israeli territory in Galilee and so on. But in 1967, it became part of under Israeli control. It remained under Israeli control in 1973. That is the Yom Kippur War, and it is in 1981 Israel adopted legislation to extend Israeli law to the Golan Heights. Again, it did not use the word annexation, but it is seen as part of the state of Israel. That is controversial because it is not part of the original mandate. But on the other hand, there are some reasons to say, well, they have a legal basis, a good legal basis. Two arguments are brought forward in that respect. First, in 1967, it was occupied by Israel in a defensive war, not a war of aggression. The aggression came from Syria, but it was a defensive war of Israel. And it was in 1967, it was arguable that territory occupied in a defensive war could become your own territory. You could get a title to that territory. That is nowadays more difficult to defend, but if you have to look at the law as it stood in 1967 to see what the legal situation is. So that's one argument. And second argument is that Israel acted from the principle of necessity. In exceptional cases of necessity, when your existence is threatened, you may, so to say, violate rules of international law that are otherwise would make you liable to a violation. But it is, if you can invoke, it is a kind of defense of necessity for this occupation of the Golan. So that is an argument that is also relevant if having regard to the way the Golan Heights were used in those days by Syria as a launching ground for rockets and devices into the state of Israel. And if we look at the situation nowadays, it would not be a very good idea to bring the Golan Heights under the control of Assad Syria or one of his militias. And it is better, I think, for the population there, Jews, both and Druze, people living there, to remain under the control of the state of Israel. So that was on Golan. That was one of the issues I have now discussed. Well, West Bank, as you know, is under Israeli control. It's not annexed by Israel. It is not. They did not make a sovereignty claim to it. They could have made so, I think, in the light of the mandate, but did not do so. But it is part of the negotiations with the Palestinians in the framework of the Oslo agreements. The same is true for the Gaza Strip. The Gaza Strip is also a special case because Israel left the Gaza Strip in 2005. Its civilians and its military were withdrawn in those days, very controversial in Israel, but they did so. But it did not lead to peace, but to more attacks from the Gaza Strip into Israel, as we know, of the subsequent Gaza wars we have seen. And in fact, Israel does not control Gaza. It is controlled by Hamas. Israel does not interfere in the internal affairs, but also only controls the borders and the airspace and of course the sea border also. So it is not a traditional case of occupation in international law.
Can I ask in the meantime,
yes?
Mr. de Blois, Jesse has a question. What is the relevance of the recognition of the Golan Heights as part of Israel by the US government in 2019 for international law?
Well, it's interesting for international law because it was in that declaration by President Trump in 2019 that especially they stressed the point of necessity, that there is an existential threat to the state of Israel from the Golan Heights. And that gives it the right to keep it under its control and to keep it as a sovereign part of the state of Israel. Now, that is another argument. I mentioned the other argument, saying the law in 1967 was arguably different. Then you could defend a conquest in defensive war could be justified. There are many examples in the history, also after the adoption of the United Nations Charter. Think of what happened after the Second World War, when great parts of Germany became under the sovereignty of Poland or the Soviet Union, and that was accepted in international law. There are other examples of acceptance, parts occupied by North Vietnam, parts of South Vietnam, that was accepted, even if it was a conquest in an aggressive war. So in a defensive war, you can easily defend that there is a good, there are many things, good arguments for Israel to say we have the right to be there. But the argument from necessity is also interesting. That was used by the Americans, and well, it was not accepted by many in the world, but I have not heard some news from Washington that they will do something about it nowadays under the new American president, but we will see. But that was about Jess's questions, I think. The question, yes.
Thank you so much.
Yes, I refer to the Oslo Agreement briefly. That is also has a territorial aspects. Of course, that is Israel and the Palestinian, the PLO, I have to say, entered into negotiations, and it resulted in the Oslo agreements, leading to a situation where the Palestinian Authority controls parts of the West Bank and Gaza. We have 3 types of areas. Well, those are details, but there is an area A where full control, civil control, but also security control is in the hands of the Palestinian Authority. We have area B where civil control is by the PA, Palestinian Authority, but the security control combined by the PA and Israel, and area C, where Israel has a full control in all respects, security and the civil control. These negotiations, well, they are not very active negotiating now, we can say. Still, the framework is there, and it is provided for in the Declaration of Principles, and and also in other agreements, that there are some issues left for a final agreement to be decided: settlements, Jerusalem, refugees, security, borders, etc. These things are to be decided. So if people say settlements are illegal because of the Oslo agreements, that is not true. They are recognized in the Oslo agreements. They are subject of negotiations. And it is also stated that Israel has the right and the duty to provide for their safety. The same about the position of Jerusalem. It is subject to negotiations. And it is also, I think, important to remark that it is not provided for in the Oslo agreements per se that it will result in a Palestinian state.
There has been many resolutions since the Oslo Agreement in the United Nations General Assembly, but as you said, they're not binding international law. They're just an opinion, expression of an opinion. What is the last bit of international law that's applicable to the West Bank or Judea and Samaria in biblical terms?
Well, I have to say it is very controversial in international. My position is that I think there are very good claims under international law, having regard to the mandate in Article 80 of the UN Charter, that Israel has sovereignty, can claim sovereignty over Judea, Samaria, and Gaza, in fact. But it has never taken that step. They only extended its sovereignty to Jerusalem, the whole area of Jerusalem. Yes, so that is, but that is a very controversial position. It is, at least in my view, the territories are not ordinary occupied territories, also not under international humanitarian law. Israel did not occupy the territory of another state in 1967. It occupied, if you use that word, parts of the mandate territory that were originally occupied by Jordan in 1948 and by Egypt, the Gaza Strip. So it is not ordinary occupied territory. You can use the term disputed territory. And I say there is a good claim of Israel, but other people would say, well, we have other views. But it is the general view within the United Nations, also of the Dutch government, is that it is occupied territory, and that all the laws in respect of those territories are applicable. Well, Israel itself does apply the humanitarian provisions of the Fourth Geneva Convention, for example, but not because it feels obliged to do so, but because it wants to have a very valid, good standard for the humanitarian regime in these areas, for the military commanders. So, but yes, it is not a very straightforward answer, but maybe you have heard my position, and it is very controversial. And at least I want to say there are very good arguments, and that is, well, there are very few within the United Nations that accept that, unfortunately. Look at the voting, the yes and no and abstention votes in the UN. Okay, we were talking about borders, but we have to move on to human rights issues. That's what I promised. And human rights, well, human rights, Israel itself respects human rights in the national law. We have to distinguish between national law and international law. In Israeli national law, the human rights are respected in general. Israel does not have a written constitution. Like the United Kingdom and New Zealand, they have no written constitution, as we have in the Netherlands, the Grondwet. But they have a constitution which is composed of unwritten rules and basic laws, as they are called. They are called basic laws, important laws that kind of replace or do the job what in other countries constitutions do, written constitutions do. And we have basic laws on specific human rights. And what is very important in Israel is that we have a very active Supreme Court, and its case law, its jurisprudence, serves as a source of the protection of human rights within Israel. Israel is also state party to many international treaties in the field of human rights, like the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, Cultural Rights, the Convention on the Elimination of Racial Discrimination, the Convention Against Torture, Convention Against Discrimination of Women, etc., the Convention on the Rights of the Child. Israel is a state party to it. And but also in the international world, and especially in the UN, we have also general supervisory mechanisms in the field of human rights, where we have specific mechanisms of supervision within these specific treaties. But we also have general supervisory framework within the United Nations Human Rights Council. That's a special institution, Human Rights Council. It's composed of 47 member states of the UN, and it's frequently and always dealing with the state of Israel and the situation in the occupied territories is a fixed agenda item. It's always on the agenda. And there's no other state in the world, North Korea or China or Saudi Arabia, does not have such a agenda item, but Israel has, and it's the great majority of its resolutions are on Israel. And recently, the Human Rights Council in last year in May, it established an international commission of inquiry to investigate violations on the occupied Palestinian territory, including in Jerusalem and in Israel. And that's a commission of inquiry which has a permanent character, and it is has a very wide mandate to look into, and I quote from the resolution, to alleged violations of international humanitarian law and all alleged violations and abuses of international human rights law leading up to and since the 13th of April 2021, and all underlying root causes of recurrent tensions, instability, protraction of conflict, including systematic discrimination and repression based on national, ethnic, racial, or religious identity. A very wide mandate, and it is a ongoing commission, independent international commission of inquiry. But if you look at the composition of the commission, 3 persons, we can have doubts about the independence. They have a very long record, these 3 members, of an anti-Israel bias in their previous positions, in their publications, etc. So it is not, I think, a commission we can look upon with much trust, and especially the State of Israel will not do so. They have already, I think, decided not to cooperate. But this commission is also provided for with an enormous budget as compared to other commissions, and it has been qualified as the most hostile anti-Israel inquisition in UN history. And of course, I think the word inquisition has not been chosen by chance. We will look what will happen. They are working on that. That is not very positive, and not very positive for a balanced approach of Israel within the human rights field, because no state is perfect. But if you look at the way Israel is approached within UN, especially within the UN Human Rights Council, we see that it is not a balanced approach, but it is exceptionally critical of Israel and overlooking abuses and human rights abuses in states like North Korea or Saudi Arabia or China, think of Tibet, and so on and so forth. But that is the way the position of Israel is within the UN. This brings me also to the apartheid allegation of Amnesty International. This year, 1st of January, adopted a report that accuses Israel of apartheid. And of course, that is a very loaded term in international law. We know apartheid refers to the system of racial discrimination in South Africa based on racial superiority of whites over people of color, and which led to a system in South Africa of unequal rights and of discrimination, and so on and so forth. And this led to an enormous international reaction within the UN and an international response, leading to binding economic sanctions against South Africa in the field of military equipment, but also in general economic boycotts, etc., by the on behalf of the United Nations, and in binding decisions by the United Nations. So that is apartheid, and there is also an international convention against apartheid. Amnesty now uses this apartheid claim, which is not new, which has been years ago. There was a South African professor of law who was a special rapporteur dealing with the Palestinian territories, already accusing Israel of apartheid. But now Amnesty has brought it forward in this report. But I think it is not correct to qualify the state of Israel as an apartheid state. There is no idea of racial superiority behind it. The ideology is missing there. If you walk around in Israel, you see people of all kinds of races and colors, Jewish people, Arab people, and so on and so forth. And there is no, in that sense, apartheid. Israeli citizens, whether they are Jews or Arabs or Druze or other, have equal rights. They can be vote and be elected. You see in the Knesset, Israeli parliament, both Jews and Arabs, also in the Israeli Supreme Court, members, Arab members, we see in the cabinet, we see Jews and Arabs, even the kingmaker of the last cabinet in Israel was an Arab, a Muslim from a Muslim party. So it is, I think it is not correct. It's even preposterous to accuse Israel of apartheid. Of course, there are, when it comes to the situation in the disputed territories, situations where there's a difference between citizens and non-citizens, which is the case in, I would say, all countries in the world. Nationality plays a role. If you have no nationality of a state, you have no voting rights, etc. in general. So there are differences. There are also differences in when it comes to the security situation in the territories. Think of roads where people with an Israeli number plate may drive and other people not. Well, that has to do with security. It has not to do with ethnicity or with being a Jew or an Arab. So I guess it is, yes, it is incorrect to accuse Israel of apartheid, having regard to that, to the situation, even if there are many things to be done and things to be negotiated about the position of Palestinians and so on and so forth, but it is not apartheid. It is, no, okay.
I think that's very clear. Thank you so
Yes.
much. Are we moving on to law of war?
Yes, exactly. That is, well, we have to say, well, unfortunately, we have to discuss the laws of war because of the situation of Israel. First of all, there is law in war. It sounds, well, these concepts look like opposite, law and war, but there is law in war. Even in biblical times, there was already law in war. We think of the work of Hugo Grotius in the past. He wrote a book of the law of peace and war and peace. And when it comes to the laws of war, we have to distinguish two aspects. First, what they call in Latin the jus ad bellum, namely the right to enter into war. When is it allowed to use violence as a state to enter into war? Under international law, there are two possible reasons, reasons to enter into war. First, when it is violence, force used, I have to say force used under the supervision and by the authorization of the Security Council. If the Security Council allows you to enter into war, that is under international law allowed. Think of the 9/11 events. then the Security Council said that the United States could undertake actions in Afghanistan against the perpetrators of these attacks on 9/11, 2001. So that is with the approval and the authorization of the Security Council. The second justification of the use of force is the individual or collective self-defense, which is provided for in Article 51 of the UN Charter. They refer to the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations. So that is an important right that was already there before the United Nations, of course, but it is still there. A point of debate is always the issue of a preemptive strike. That means if there is an immediate threat, are you allowed to give the first blow, or to give the first strike? That may be relevant in the present situation. Think of the developments in Iran. Would Israel be allowed to destroy the nuclear facilities before Iran attacks Israel? Well, there is a doctrine of preemptive strikes that allows for a preemptive strike as self-defense in case of an imminent, overwhelming, leaving no choice of means and no moment of deliberation attack. If that is pending, an imminent attack, you may act first. Well, that is of course relevant, as I said, in case of the of Iran. But Article 51 was also relevant when it, in the advisory opinion I discussed earlier on the security fence in Israel, because Israel said in the defense of its security fence, it is a kind of self-defense. We are faced with suicide attacks. And the only thing to protect yourself against suicide attacks is by physical means, because suicide attackers are not impressed by threats of punishments or even military actions. They want to die. So that is not. So how do we protect our citizens against suicide attacks? Well, by building a physical structure of a wall or a fence or whatever. And that was very successful. Israel said, well, this is an application of Article 51 self-defense. But surprisingly, the International Court of Justice, at least the majority of it, interpreted this right to self-defense in a very narrow way. They said they can only invoke it in case a state is attacked by another state. And these attacks were from terrorist groups, Palestinian terrorist groups, and not by another state per se. But that is not at all in Article 51 of the UN Charter. It does not refer to an attack by another state. And even the Security Council, as I said in 2001, in case of the 9/11 event, accepted the attacks in the US were not by another state, but by terrorists, Al-Qaeda, located in another state, but they were not by the state of Afghanistan, but they were by Al-Qaeda. And in those days, even the Security Council accepted a wider interpretation of Article 51, also attacks by non-state actors. And that is, historically speaking, also has always been the case when it comes to the right to self-defense. There's a famous case in the 19th century, Caroline case, where it was about the defense in the US against people who wanted to enter United States and attacked the US from Canada, but they were not the British government, but they were kind of terrorists. So that is a very strange argument of the International Court of Justice, has been criticized also from within the court. Even a judge who was voting for the ruling was very critical. Rosalind Higgins, Lady Rosalind Higgins, she was very critical, and the British judge. But nevertheless, that was the position of the International Court. But I think Israel has a right to self-defense also against these terrorist groups. So that about the first thing, the use at bellum, which means the right to enter, to use force, to enter war. Another aspect is what they call in Latin the use in bello. That means what is permissible in war, means in terms of the form, extent, and target of the use of force. What may you use? What kind of force? What kind of military operation you may undertake in the case of war? And that is the body of the rules we find in the so-called international humanitarian law, the Geneva Conventions, Red Cross Conventions, they are sometimes called. And I mentioned two very important principles in that respect. First, there is the principle of distinction. That's the basic rule, is that you have to distinguish in your actions between combatants, say soldiers, and non-combatants, say civilians. You have to make that distinction. And that is particularly difficult in case of the warfare Israel is facing, the terroristic warfare, because terrorist groups have as a kind of tactic even strategy to hide between and among and behind citizens and civilian objects like schools, like hospitals, like mosques. And that's what happened in the subsequent Gaza wars. Hamas terrorists were hiding and creating launching installations in civilian buildings or areas. And that makes it very difficult for Israel to preserve the principle of distinction. Therefore, we see also many casualties among civilians. They are forced to protect the military installations. And that is in itself, using civilians as a shield is in itself against the laws of war, against humanitarian law. So Hamas could be accused of war crimes in that respect. That is the principle of distinction. Another principle is proportionality. The use of force should be proportional in relation to the military objective you want to achieve, what you anticipate. So the use of force has to be proportional and not excessive. And that is not always simple, and it is sometimes, and also in Israel, sometimes refrains from action because they are afraid there will be too many civilian casualties or so. It is not just about calculation of the number of victims. Sometimes on television, showing numbers especially in the case of the Gaza wars, we saw on television so many people killed on the Israeli side and so many killed on the Palestinian side, and there were many more killed on the Palestinian side. That does not mean per se that is not proportional, because then we have the same principle in national law, by the way, self-defense. If you have to defend yourself in an alley, you are threatened by a person who wants to take your life. If you kill him first, then that can be justified as under the law as self-defense, also in national law. But it does not mean it has been disproportional because the other one died and you are still alive. So it's 1 to 0. So, well, that also counts is relevant for the for the warfare Israel is facing.
But because of the sheer quantity, you just have two numbers. You can say, hey, this is disproportional, although that might be a mistake in thinking. Yeah.
That I guess that is mistaken as such, because you have to compare the objective, military objective, and the and the means you use.
We have approximately 7 minutes. Is it can I allow some people to ask their questions, or do you want to finish it up first, Mr. de Blois?
You're welcome. Yes.
Yeah.
Well, I can stop here. I had some other things, but I think having regard to the time, it's maybe good to stop here. I had something about the ICC, but I stop here, and then I am.
ICC is a whole different webinar, don't you think? Yes. I want to ask Albert Klaas to ask his question in the Q&A, and also want to ask Albert Harmsel, like last week, to ask some good questions. I know you can. First question is about your introduction. Hannah Luden is WhatsApping me actually, and she's asking.
I know her.
How objective is international law? And if I can rephrase her a little bit, where is the space for interpretation, and who is to make that interpretation?
Yes, a very good question. Brings us to the heart of international law. It is indeed subject to interpretation, and because many parts of international law use wide principles. I quoted from the self-defense and other examples. So there's a lot of room for interpretation, and in principle, there is interpretation by the states that have to act according to international law. First of all, there is interpretation within, as we see, within the United Nations. There is interpretation within courts, but even courts, they have all different views. I refer to the International Court of Justice. It is a custom there that judges may include their personal opinions and attach them to the judgment. In many cases, if not all cases, they do so. And we see a whole variety of views about the interpretation of international law. So there's much room. And yes, what if you mean by objectivity that there's only one answer given? It is a struggle for the right answer, I guess. A debate, an ongoing debate for the right answer, which I think is familiar to the Jewish tradition also. An ongoing debate on the right answer and the right interpretation, but using arguments, framing your arguments within, well, say the norms of a treaty or customary law. That's a kind of common language, but then you have to interpret, and that's where the differences appear. And they cannot be solved in a way by saying, well, this is one pope who decides what is the right answer. I hope that Hannah is a bit satisfied by this answer. Maybe we can continue the discussion later on.
Yeah. Albert Harmsel is asking 3-in-1 question. Okay, 3 questions in one. Maybe your arguments on Israel are legally right, but isn't it better for Israel and definitely more fair to the Palestinians to give in to the demands by Palestinian people? For example, in building permits in Area C, for example, more freedom to travel, for example, to have their own state, which was part of the petition plan, the Jews in Palestine accepted.
Well, of course, there are negotiations. There's a framework of international law. There is no rule, I think, in international law that imposes the outcome of either a Palestinian state or no Palestinian state, some other type of autonomy. Even if I think in the present, personally, I think it is very difficult for Israel to accept a Palestinian state. having regard to historic experience, also with Gaza, etc. But I think indeed, yes, you can, of course, within the framework of this security cooperation, if it's in the framework of Oslo, it is possible, it has been possible to come to some sort of practical solution for practical problems of people working in Israel, for permits, for travel, for, yes, the issue of statehood. I think in the present situation is very difficult. And of course, Palestine claims it is a state. It is not a state in international law terms. But I think when you come to if you want to find a solution, it needs two parties. And you also have to satisfy from a Palestinian side, the other party, that they can, well, that can lead to a safe solution. We think of Gaza. It was decided by the Israeli government under enormous opposition within its own parliament, also in the Knesset, to leave Gaza, to withdraw the troops, but also the civilians there, to bring down the settlements. And that does not lead to any form of peace or security. On the other hand, it became a huge launching ground for attacks on civilians in Israel. Well, if that's the picture, then I can imagine that there is, and also having regard to the leadership, Palestinian leadership, is there a leadership that can be trusted? It is very complex, and in Israel they will know it much better than I can say here from my position. But I think it is very difficult. But if there are practical solutions, yes, yes, there also in Israel people are open to that, and also the present government, I think. But it is very, very complex. We think we have been some years ago in Israel, but also were received in Ramallah by the PLO, where they gave a presentation on their position. It was possible for our group to be there. And so hopefully there will be new leadership that will give trust to make it possible for the Israeli to trust a cooperation in the future.
Well, and on that hopeful note, thank you so much for your questions, and a special thanks, of course, to our guest of today, our expert of today. I want to tell again the organization where you work for. You used to work for the Utrecht University, the biggest university of the Netherlands, and now you are a senior fellow at the Hague Initiative for International Cooperation, thinc, with a C. This video is on demand available. You can share it via our YouTube channel, CIDI TV. Next week, it fits actually pretty nicely into the topic we dug in today. We are hearing about Jakobovic. The webinar will be about the security concerns regarding the two Palestinian territories. And in the meantime, make sure to listen to our Dutch podcast, Misrach. So till next week, it's on Wednesday, 10 o'clock. And thank you so much for your questions and your attendance.
Thank you very much. Have a nice Purim. See you.
motion to go in